The Supreme Court tests the viability of Roe v. Wade again. Hi, this is Shawn Akers, Vice President for Middle Eastern Affairs with Liberty Counsel, in for Matt Staver today. And joining me in studio today is Deryl Edwards, the President of Liberty Counsel Action. Deryl, it's good to have you with us today.
Thank you, Shawn. Good to be here.
Deryl, this is a case that should not be surprising, but is very, very exciting. Let me give you just a little bit of background on it. In several cases in the United States, the question has come up many, many times of whether an unborn child, and in what cases an unborn child, should be treated like a person. Now, those of us who have who follow a Judeo-Christian worldview typically find that God created us, that He spoke us into being, that He said He knew us when He formed us in our mother's womb, and that pretty well solves the issue for us. Now, in terms of science and morality, the courts have batted this back and forth for the last 50 years or so in a variety of ways, which culminated in the decision of Roe versus Wade, which set some parameters that we've had to deal with ever since. Now, what went on in this particular Alabama case is the question came up of not just whether an unborn child can be treated as a person for purposes of a wrongful death case, but an unborn child that has not reached this arbitrary line that we call viability. In other words, if the child were born today, is the child in a position to survive on its own, on his or her own? So that's the question that the court addressed, and the answer is one that's been very surprising.
You're exactly right, Shawn, and one of the things we're seeing is these cases are whittling away at Roe and making it to show it to be outdated, not that it was ever a proper decision, but with the advances, as you and I spoke earlier, in science and technology, we're seeing more and more that life is real from the moment of conception, that it exists from the moment of conception, and to stop that life, whether there's viability outside the womb or not, is to kill a living human being.
Well, and here's what the court did in this case. Up to this time, this suit was brought by a lady who was claiming that her unborn, unviable, meaning that the child was not far enough along to technically survive on its own under current medical technology, she claimed that this baby was allowed to die in her womb because of a lack of care of a group of physicians. It was thrown out on summary judgment. A court granted summary judgment against her, a lower court, saying that because the baby wasn't viable, there's no wrongful death case to be had. The Alabama Supreme Court took that case and said, we're going to reverse it, that's an arbitrary distinction. And what's happening, Deryl, is that we're seeing in very much the same way that the decision of Dred Scott dealing with slavery, as science, as morality, as common sense took hold, people saw that what was going on was a travesty with the Dred Scott case. We're seeing the same exact thing happen slowly but surely with the abortion issue. And here the Alabama Supreme Court has said that viability changes with medical technology. That, what viability 10 years ago is not viability today. Viability at the time of Roe v. Wade is not viability today. We've increased our ability to save the life, to help a child live on its own as time progressed. So how can we tax the child? How can we penalize the child for our lack of technology? In other words, in a perfect world, couldn't we, if we had perfect science, couldn't we make the child viable all the way to the point of conception? If that's the case, then how can we ever tax the child for not being anything that the child is, i.e. human, based on our inability to provide medical services? is really what the court's getting at. How can we be the arbitrary decider of when you become a person?
And that's a problem when you base legal decisions a lot of times on human wisdom. Roe v. Wade was based on human wisdom circa 1970s and that era, and things have changed. And the viability decision, as you said, can change with medical advances. Let me read a little bit from the opinion of Justice Tom Parker of the Alabama Supreme Court, who said, "Today this court reaffirms that the lives of unborn children are protected by Alabama's wrongful death statute regardless of viability." And he goes on to say that that there's a diminishing influence of Roe's viability standard, and he concludes here saying Roe's viability standard should be universally abandoned.
Very strong language and very right language. And there's a deeper philosophical issue here as well, Deryl. One is he's showing, the Alabama Supreme Court is showing that our determinations of viability just aren't a proper standard to judge when there should be a wrongful death suit available for the death of an unborn child. But deeper than that, doesn't this really expose the arrogance of a legal system that would presume to play God in these situations? Isn't that really what we're getting at? Isn't that really the tug of war that we're dealing with? Are one side of the equation that says man will be God and decide who is and who is not entitled to life, and the other side saying, no, wait a minute, law can't stretch that far. God has to be God and decide who is and who isn't human, and that or entitled to life, and that law's job, according to people like Frederic Bastiat, is to protect the right of life, liberty, and property, not the role of deciding who is entitled to it.
And when you move into the area, as you were saying, where man makes that decision, you inevitably begin to slip into tyranny, and we can look back through the governments in the past, whether it's Nazi Germany or Communist China and others, and they said we reserve that right to ourselves to decide who is worthy of life. The state is worthy, will make that decision, and that's where you begin to slip in that direction. And I'm glad this ruling seems to be moving in the opposite direction.
Exactly. We have to make determinations, Deryl, and the question becomes how we're going to make those. From an objective Judeo-Christian standpoint, we're saying that, we're going to see life as something that is intrinsically valuable, that exists with or without our permission or acknowledgement, and that that there is literally a self-evident, as the founders called it, right to life that exists whether you see it, whether you don't, whether you agree, whether you disagree. It doesn't require your concession for it to exist. Now, on the other side of that equation, though, is the thought that man decides. And if man decides, the question becomes how? Is life decided by quality of life? Do we think that being is going to live in a way that we think will make it happy? Is it value to the state, as is what you really see it devolve into in fascist Germany under the Hitler regime, when the real question was who is most profitable to the state, and even at that time you can see it really becomes very illogical, because even people, the Jewish population was very, very profitable to the state. But yet a hatred boiled under the surface there that made them the non-human for purposes of German law, the same way that slavery made non-humans or less than humans for purposes of American law, and the same way that Roe v. Wade made the unborn non-humans for purposes of American law. We cannot legitimately play God.
Well, once you let that mindset start to take over, then you can rationalize whatever group that you have animus towards to make them less than worthy of life, or make them worthy of a lesser treatment than others. And the whole idea of equality under law, which liberals seem to just love to claim seems to go out the window when they don't really practice it.
That's exactly right. If you would like to find out more, let me tell you, we have a free 19-page summary that you can get on the lc.org website. Go to it now. Pull down this document. Go to lc.org or call us at 1-800-671-1776.